Hello everyone, we are Sarah, Lana, Elena and Thalia, and we will begin our presentation. Imagine you are fleeing your country, you undertake a dangerous journey, you are terrified, exhausted, and finally you set foot on European soil. You seek out state authorities and express your intention to apply for asylum. But before those words can mean anything, you are gone. Within hours, you are forced back to the country you came from. There is no registration, no official record that you were ever there. Subsequently, you seek to challenge this treatment before the European Court of Human Rights. In response, the court poses a seemingly straightforward evidentiary question: can you prove this claim? This is at the heart of today's presentation. We are going to talk about the evidentiary questions of challenges of pushback cases against asylum seekers. So today we ask, how does an asylum seeker prove the improvable?
Before we dive deeper into this topic, a little explanation is needed about what pushbacks are. Pushbacks are informal expulsions that take place outside any legal procedure. Migrants are removed without being registered, without access to asylum, and without any possibility to challenge the decision. What is crucial for our topic is that these practices are designed to leave no trace, the so-called no-paper pushbacks. From a legal perspective, these individuals are protected under the European Convention on Human Rights. Pushbacks violate the principle of non-refoulement, which prohibits returning individuals to a country where they face a real risk of torture, inhumane or degrading treatment, or even threats to their life. Moreover, the way pushbacks are carried out itself may amount to inhumane or degrading treatment. In addition, these practices often involve the collective expulsion of individuals without any form of individual assessment. And finally, individuals are typically denied the opportunity to challenge their removal, meaning that their right to an effective remedy is not respected. However, in practice, when individuals try to invoke these rights, they encounter significant obstacles. Because of these no-paper pushbacks, it is extremely difficult to prove that pushbacks even occurred, which creates a fundamental evidentiary problem. These practices are designed in a way that prevents the creation of evidence. There are no records, no registration, and victims are often immediately removed from a territory. This is especially problematic because there is a limited time to bring a case before the European Court of Human Rights, more specifically 4 months. At the same time, the state controls all relevant information and can simply deny that anything has happened. Importantly, the absence of evidence is not accidental. It is part of how the violation operates. As a result, many cases are never even registered by the court or are rejected at admissibility stage. Because of these evidentiary problems, the traditional principle of actori incumbit probatio, where the burden of proof lies with the applicant, is insufficient. The applicant cannot access the necessary evidence because it is either controlled or deliberately suppressed by the state. As a result, claims risk being rejected for lack of proof even when violations have clearly occurred. And this brings us to our next question. Should the burden of proof be shifted to the states in these cases?
First, let's have a look at some theoretical insights. The court has developed a framework specifically designed to deal with situations of differential access to information. This framework allows the burden of proof to shift from the applicant to the state. This doesn't happen automatically, however, but it depends on 2 conditions. The first condition commands that there exists a context which indicates that the respondent state may have acted in the way as is claimed by the complainant. This must be established on the balance of probabilities, for example, because the state is known to have previously been acting in the way as is described by the complainant. Secondly, the linkage condition commands the plausibility that the claimant was personally affected by the presumed events, which only needs to be established prima facie. If these 2 conditions are met, the adjudicator must shift the burden of proof onto the state.
ARE Greece and GRJ Greece are 2 closely related judgments from 2025 of the European Court of Human Rights concerning alleged pushbacks from Greece to Turkey. For practical purposes, we will refer to these cases as Case A and Case G in our presentation. In both cases, the applicants claimed that they had crossed into Greek territory. They were apprehended by Greek authorities and forcibly returned to Turkey without access to asylum procedures. The Greek government categorically denied both the individual allegations and the existence of any such pushback practice. The context condition plays a foundational role in the court's reasoning because it frames the broader factual and structural environment. It concerns whether there existed, at the relevant time, a systemic practice of pushbacks by Greece to Turkey. It also reflects an understanding that certain types of violations are often systemic in nature, involving a repeated practice rather than one-off acts. The court is clear that even a well-established pattern of systemic violations does not automatically prove that a particular applicant was a victim, and we can see this in paragraph 217 of Case A and paragraph 282 of Case G. This is why, in both judgments, the court insists that the establishment of this kind of practice does not exempt the applicant from providing prima facie evidence of their own experience. The context condition strengthens the plausibility of a claim, but it does not replace the need for individual proof. In both cases, the context condition was equally satisfied. The court accepted that systemic pushbacks were taking place in both the Evros region and the Greek islands. The court based this finding on an extensive body of documentation, noting the large number, variety, and concordance of the relevant sources, including reports by numerous national and international organizations, all of which consistently recorded a systemic pushback practice at the Greek-Turkey border. Yet this shared finding did not lead to the shared outcome. The decisive difference lay not in the context condition, but in the linkage condition. That is, whether each applicant could connect their personal experiences to this broader pattern. The victims of pushback cases face a steep challenge in establishing the linkage condition. The A and G cases demonstrate the two diverging paths that a pushback case can take. The linkage condition must be proven prima facie. The court requires that an applicant demonstrates that their individual account is connected to the established systemic practice through detailed, specific, and coherent evidence that is free from contradictions and supported by concrete, comprehensive, and concordant material. And we can see this in paragraph 217 from the ARE judgment. The contrast between the two cases illustrates the problem clearly. In Case A, the applicant provided an unusually strong evidentiary record. She shared her live location via WhatsApp during her journey. She sent photos and videos confirming her presence on Greek soil and was physically located by a lawyer who later witnessed this arrest. This accumulation of real-time third-party verified evidence enabled the court to find that her account met the required evidentiary standard. Consequently, the burden shifted to Greece, and the court ultimately found a violation of the convention. By contrast, in Case G, the applicant's account, while consistent with the established modus operandi of pushbacks, failed to meet the linkage threshold. The court accepted that his narrative aligned with well-documented practices, but emphasized that such alignment alone was insufficient. The applicant lacked concrete proof of his presence in Greece and could not clearly link the available evidence, such as photos, videos, or a Turkish Coast Guard report, to himself personally. As a result, the court concluded that he had not established prima facie victim status and declared the application inadmissible rationale personae, despite acknowledging that similar pushbacks likely occurred. The court explicitly recognizes that pushbacks are inherently secretive, informal, and undocumented, often involving the confiscation of phones and the deliberate avoidance of official records. It also acknowledges that states typically deny such practices outright, as Greece did in both cases, by disputing not only the events, but even the applicant's presence on its territory. Yet, despite this recognition, the court insists on a high level of evidentiary precision from its applicants. As demonstrated by the divergence between Case A and Case G, the result is that only exceptionally well-documented cases succeed, while many plausible claims fail at the admissibility stage.
Now, let us examine the critical insights. The first line of criticism concerns the standard of proof that the European Court applies in practice. In principle, once an applicant provides prima facie evidence, the burden of proof should be shifted to the respondent state. However, the court seems to demand stronger evidence, which is then labeled as prima facie evidence. In the A case, the applicant had exceptionally well-documented evidence. She was able to provide live location data, a lawyer present at her arrest, and Turkish court records with timestamps. In our point of view, shifting the burden of proof was not needed since she was able to establish her case beyond reasonable doubt. Even the court itself concludes that the applicant's allegations are sufficiently convincing and established beyond reasonable doubt. It nonetheless applied the prima facie standard and shifted the burden of proof to the state. It is crucial that the court keeps to the proper meaning of prima facie. It needs to recognize when a shift is not needed due to the strength of the evidence. Overusing this mechanism may lead to raising the prima facie threshold, making it harder for claimants to prove their allegations. The G case illustrates that consequence perfectly. An applicant without such exceptional evidence has failed to meet the court de facto prima facie standard, and his case was dismissed, even as the court recognizes Greece's systematic practice of pushbacks. This leads directly to our second critique, namely the court's failure to give adequate weight to the established systematic practice. In both cases, the court recognizes that Greece has an ongoing practice of pushing back migrants across its border. Therefore, it should suffice for the applicant to demonstrate their presence at the respondent state territory and their subsequent presence at the third state. So it should be enough for an individual to show, I was in Greece, the next day I was in Turkey, the systematic practice is the link. However, in the G case, the systematic context was not allowed to play that role. The court treated the broader pattern as background instead of plausible evidence in combination with the statements of the applicant. We submit that the applicant in the G case has established his case with prima facie evidence, notwithstanding his inconsistencies in his testimony. The possible visual evidence placing him at the scene, when assessed in conjunction with the well-documented evidence of the systematic practice, renders his account plausible, and plausibility, not probability, is the appropriate threshold at the prima facie stage. Taken together, these two critiques poses a troubling paradox. The mechanism that is meant to protect vulnerable people is being applied in a way that only protects those who don't really need it and abandon those who do. In simpler terms, the case with the weak evidence did not succeed, yet this was precisely the case that generally needed that protection. Meanwhile, the case with the near-perfect evidence did succeed, even though it hardly needed that protection since the evidence was strong enough to stand on its own.
Now let's have a look at how the court could actually gather more evidence when states fail to record or actively obstruct evidence production at borders. First, under its procedural rules, the court can actively request evidence from states such as documents, recordings, asylum records. These documents could amount to prima facie evidence allowing for a shift in the burden of proof. Second, there are procedural obligations related to, for example, the principle of non-refoulement, by which states have a duty to record what happens at borders and investigate alleged violations. By insisting on states to respect procedural obligations, the court actually urges them to produce records and conduct effective investigations. Focusing on procedural obligations to produce evidence can help compensate for missing evidence. Third, interim measures could have evidentiary value. They are meant to prevent irreparable harm when there is an immediate risk to rights. But besides their original purpose, they could also make pushback cases more visible. Accepting an interim measure per se does not suffice to evidence that an incident has indeed occurred. However, many accepted interim measures can point to a pattern, for example, of not accepting asylum applications at a border crossing. This can then play a role in establishing, for example, the context condition. Equally, the court can draw inferences if a state does not follow an interim request. Fourth, the court could go further and use investigative tools such as appointing experts, requesting independent observers at borders, or asking for surveillance data. These tools will allow the court to move beyond passive adjudication towards a more active fact-finding. Finally, the court can change how it evaluates evidence. For example, as we talked about, it can shift the burden of proof based on actual prima facie evidence or based on inferences and give more weight to NGOs and third-party interventions. These actors often have the best knowledge of what is happening at borders, yet their evidence is still undervalued. Now, a key question is that if all these tools exist, why are they not used more? This question brings us to institutional and political constraints. The court operates in a context where it depends on state cooperation for the production of evidence and for the execution of its judgments. In sensitive areas such as migration control, this creates a strong incentive for the court to act cautiously. This caution is then reflected in its evidentiary practice. Rather than fully relying on tools like burden shifting, presumptions, or inferences, the court often requires more concrete and individualized proof from applicants and has more trust in what the state claims to have happened. The fact that the court is not bound by strict evidentiary rules but applies a rather flexible approach to evidence also allows states to put pressure on the court more easily. This practice aligns with the concept of raison de cour as developed by Professor Dembour, which describes a form of judicial self-preservation whereby the court avoids politically sensitive findings in order to prevent backlash from member states. In this logic, the court saves the state in order to save itself. In the context of pushback cases, this dynamic becomes particularly visible. The court often adopts a differential attitude towards states, explicitly recognizing the difficult and exceptional circumstances surrounding migration control, which already frames its assessment in a state-sensitive manner. This is reinforced by the application of higher evidentiary thresholds. Applicants are required to provide unusually strong and individualized proof, even in situations where the court acknowledges structural obstacles to evidence production. At the same time, the court may engage in what has been described as strategic ignorance, downplaying broader patterns of state practice or failing to draw consequences from missing evidence that lies within the exclusive control of the state, such as border recordings. These practices together create what can be understood as an evidentiary smokescreen. While maintaining the appearance of rigorous fact-finding, the court effectively sets standards that are difficult, if not impossible, for applicants to meet. As a result, states are often able to evade accountability for covert practices like pushback cases, despite the existence of tools such as burden shifting that could have been used differently. In other words, evidentiary standards are not applied in a purely neutral way, but are shaped by an underlying concern to avoid direct confrontation with states in politically contested areas, such as border control. This becomes particularly clear when we compare pushback cases with enforced disappearance cases. In disappearance cases, the court explicitly recognizes that first, the state controls the evidence, second, documentation is often absent, and third, applicants are in a structurally weak position. As a result, it is more willing to shift the burden of proof, rely on circumstantial evidence, and to draw strong inferences from state silence and non-cooperation. However, in pushback cases where these same evidentiary conditions largely exist, the court applies these tools much more restrictively. This difference cannot be explained by legal reasoning alone, but reflects the greater political sensitivity of migration control compared to disappearance cases. The difference in evidentiary approach between these types of cases illustrates how political context shapes the court's willingness to use its own evidentiary tools.
We began this presentation with a simple but troubling question. How does an asylum seeker prove the improvable? What we have shown is that the difficulty is not accidental. Pushbacks are designed to leave no trace, and the resulting absence of evidence is not a failure of the applicant, but a feature of the violation itself. While the European Court of Human Rights has developed tools to address such evidentiary asymmetries, such as the shift in the burden of proof, our analysis of these cases demonstrates that these tools are not applied consistently in practice. Instead, the court often maintains a high evidentiary threshold, even in contexts where it recognizes the existence of systematic violations. This leads us to a paradox. The mechanisms intended to protect the most vulnerable applicants end up benefiting only those who can already prove their case with exceptional evidence, while those facing the greatest evidentiary obstacles are left without the protection. Ultimately, this is not just a technical issue of evidence law. It reflects a deeper tension between legal reasoning and political context. As our comparison with enforced disappearance cases shows, the court is capable of adapting its evidentiary approach when it is willing to do so. The question, therefore, is not whether the tools exist, but whether they are being used. If human rights protection is to remain effective, the court must align its evidentiary standard with the realities of the violations it is asked to assess. Otherwise, it risks allowing precisely those practices that are designed to remain invisible to escape legal consequences. And so we return to our initial question. The problem is not that asylum seekers cannot prove their claims. The problem is that the legal framework still expects them to meet such a high evidentiary threshold. Thank you for listening. In these slides, you can see our bibliography and of the sources we used, and an interesting video for if you would like to dive deeper into this topic. Goodbye.